Assalamualaikum and good day. I bid to Sir Fidaus. My name is Tian Azrena Minti Ahmad Rizal, metric number 244359, and today I will be presenting the case of Perkins against Jeffery. On 16 July 1914 at 7:30 am, a female who was 20 years of age named Kathleen Turner was boating on the pool in Small Heath Park by herself. This is when she saw the respondent at the end of the pool and that he was exposing his private part to her. Due to the shock, she quickly rowed to the end of the pool and complained to the boatman. The boatman who came up to the respondent and said, "Is this the man?" Miss Turner said it was, upon which the respondent said, "I think you have made a mistake here." She said, "I have not." She also said, "I had seen the respondent in early part of May 1914. The respondent was then arrested. He said, "They have made a mistake. They have got the wrong man." In giving evidence on his own behalf, the respondent denied having been guilty of the offence, and in cross-examination he said, "I do not remember seeing her on the first or second week in May 1914. He was then asked, also in cross-examination, "Do you deny exposing yourself to the same young lady in Small Heath Park in the first or second week in May last?" The respondent replied, "I do deny it." The main issue of this case is whether the evidence was admissible on the part of the complainant that the respondent had exposed himself in the month of May. The court decided that the justice were determined and found as a fact that there was no sufficient evidence given by the appellant in order to satisfy them that the respondent was guilty of the offence charged. Therefore, the respondent was discharged by the justice. Based on this case, we can see that there is an application of similar fact evidence. What is similar fact evidence? Similar fact evidence, or SFE, is where circumstances are evidence in which the accused's previous misconduct, other than which gave rise to the offence charge, are made admissible in court because of the similarity to the offence. The general rule of SFE is that SFE shows previous misconduct of an accused to prove the current offence is not admissible due to the presumption in the criminal justice system that an accused is presumed innocent until proven guilty. However, based in the case of Mackin versus Attorney General of New South Wales, the second limb of the judgment allows for the admissibility of SFE if it shows the current misconduct was designed to rebut the likelihood of it being accidental, and number 3 is to rebut any defence raised by the accused. This is called the specific purpose test. The court held that in this case that the accused were rightly convicted and affirmed by the Supreme Court. However, due to the approach being highly criticised, other tests can be used as an alternative to admit SFE, namely the striking similarity test and the probative value test. The general rule is that the likelihood of coincidence becomes less and less likely when people make similar allegations, and more striking the similarities are, the more unlikely the possibility of coincidence. The question in the cross-examination and evidence of Miss T directed to show that the respondent had done the same thing at the same place and to the same moment. In my opinion, the evidence standard were admissible and relevant for the purpose of showing that Miss T was not mistaken in her identification. It shows that the respondent had done it willfully, not accidentally, and it was done with the intent to insult her. As mentioned in the case of Mackins, SFE is admissible if it shows that the current misconduct was designed, or to rebut the likelihood of being accidental, or to rebut the defence raised by the accused. However, as the approach in Mackins is rather impossible to provide a conclusive solution, the striking similarity test and probative value test can be an alternative to the specific purpose test. In applying the test, Miss T must prove the repetition of previous misconduct and the current one charged is strikingly similar, and whether the probative value of the evidence outweighs its prejudicial effects. Thus, the evidence that Misty directed to show that he had done the same thing at the same place and to the same woman shall be admissible. In conclusion, based on the application of SFE, the question put to the respondent in cross-examination, an evidence standard of Misty to show that respondent had been guilty of the same conduct to her at the same place in 1914 May should have been rendered admissible and relevant for the purpose of showing that Misty was not mistaken in her identification. That is all for my presentation on the case of Perkins against Jeffery on the topic of similar fact evidence. Thank you for watching.